Welcome to 42 Bed of Row's latest webinar. Tonight's webinar is on memory and family proceedings and is presented by me, Damien Woodward-Carlton, and Sharon Batchew. We're both members of the 42 Bedford Row family team. This is obviously a huge subject. It's necessary, therefore, that we're going to be selective. We're going to dip our toe into a huge pool of information and only try to deal with those things that give us a helpful guide to how we as family practitioners can consider the issues of memory in family proceedings, particularly fact-finding, but more generally as well, to inform our practice and better assist our clients. So the way we're going to structure today is I'll do a brief introduction about what we're doing. We will then deal with aspects of the law as it's set out in case law. Sharon and I will set out some of that. We will then move into some areas of research, neuroscience, psychology, without getting too technical and too detailed, but setting out some of the latest thinking just to give a feel of that, some of the debates that are going on, and how some of those debates are informing practice both here and abroad. And finally, we'll look at some more practical considerations in our own practice and application, including, which Sharon will deal with at the end as well, vulnerable witnesses and the particular emphasis we need to place on them and thoughts we need to give. So the reason we're doing this is that so often when we do family cases, we find ourselves, certainly I do, and I think Sharon and I both agreed on this, that we find ourselves sitting in cases where we hear a question asked, it might be even something we're asking of a witness about events that happened months, sometimes years before, events that were traumatic at the time, or perhaps weren't seen to be particularly important for the witness at the time. This could be a witness who's not involved or a party who's heavily involved in family proceedings. And it strikes us so often that we wouldn't be able to tell the court what we were doing last week, never mind last year. And that there's a need, therefore, somehow to avoid the indolence of thinking about memory as just something that's quite simple and linear and not too difficult, and that actually we need to grapple with some of the complexities and some of the limitations if we're going to do things properly and fairly. So the nature and limitations of memory underlie pretty much everything we do in the family courts, particularly where there are disputed facts. And this is particularly important for family cases compared with other areas of law, because setting aside social media and texts and things such as that, which have their place, what tends not to happen in family law is that we don't have documentation of the things we're talking about. We might later on, when professionals become involved, we'll have social work reports, but we don't have, as a matter of daily activity in families, the documenting of life, apart from possibly diaries, which perhaps bring their own peculiar complexities to a case. So we rely inevitably on people's eyewitness accounts, their memory of what happened. And what we're dealing with generally in family cases are hugely emotional situations, traumatic situations, situations in which the parties particularly have a huge amount at stake. And given the nature of the sanctions and the nature of the arrangements that can be made for children in this country, in some situations where permanent removal is contemplated or a possibility, then there's possibly nothing more draconian that the court can do. And therefore, finding oneself in that situation, giving evidence, knowing what's at stake, inevitably, we will point out, can dramatically influence the ability, never mind the willingness of people to remember clearly. The problems with memory are set out in our case law. They're reflected in rules that we will refer to. But all too often, they appear in a pack of law that's sent to the court as part of a hearing for the court to bear in mind because it's relevant law. And this is a practice that has recently been deprecated. And buried in there are some pearls of wisdom about the nature and the fallibility and the limitations of human memory. The danger is we skim over those and give them a quick nod and then get on with business as usual. And so what we're trying to do briefly this afternoon is to locate and consider that information, both in the case law, in some of the research, and some of the procedural rules and regulations that we have that give us clues as to how we should be approaching this, and build this in, or start to at least, to become a natural and standard part of the way we represent our clients, the way we prepare our cases and the way we advocate in court. So we are going to go onto the law, but before we do that, I think it would be helpful to have at the back of our minds when we're thinking about this, the broad basic scenario that a lot of care cases follow, or at least the events that lead to the care case, and have at the back of our mind what implications these may have for people's ability and willingness to store memories, to recall them accurately. And when we go through particularly the research material and bearing this process in mind, the process our clients go through, then I think it will become clear that perhaps there's a need to reevaluate and recalibrate our practice in dealing with such things. So a typical child protection scenario might involve an event or events. And it might be a single incident, perhaps an injury to a child. It might be a violent incident. It might be a combination of the above, and it might be something that's sustained over time, a series of incidents. Now, these incidents are going to be experienced in different ways by different people, obviously. They're going to be experienced through things they hear, through things they see, through things they feel. But even if it was a single incident, there is then often, let's say, an incident that leads to injury or suspected injury to a child. There is then in the immediate aftermath a need by parents or carers and other family members to deal with a range of other people. And many of those are professionals. So it could be ambulance staff, it could be other emergency workers, medical staff in A&E, it can be the A&E staff, nurses, the triage through to treating doctors. If it's late at night, which is not unusual, the shift will change during the night probably, and then again in the morning. And to all these different people, accounts will be given, questions will be asked, there'll be an interaction in stressful situations. The clients will probably be up all night. They'll be frightened and panicked. They'll be worried for their child. They'll be worried for themselves. They will no doubt be being contacted and trying to contact family and friends. There'll be messages going back and forwards, phone calls. There'll be more doctors. Inevitably, in our scenario, there will be social workers involved at some point when a suspicion is raised. And then the police, probably. The investigation then starts. The police ask questions. There are interviews. We'll come back to that. And then at some point, we as lawyers arrive. We'll probably be delayed in terms of coming to this scenario, and we'll be working with the products of everything that's gone before, all the questions, all the concern, the accumulated emotion and uncertainties will all be playing a part in what we're able to do with and for our clients at that stage. We won't have been part of those initial conversations or part of the questioning by professionals. One of the things that happens for clients, particularly, and other witnesses, but one of them is that they are asked to recall events themselves in the context of other people's accounts. So they're perhaps told what other people are saying, they're given things to read in terms of what other people have said, and asked to comment or to recall in the light of that. And throughout all this process, they are probably and possibly increasingly realizing quite how profoundly difficult their situation is and the range of possible implications, those implications medically for a family member, personally and socially, and also legally. And sometime during this process, the court process starts. So when we're thinking about the features of human memory, we need to locate it in a process that in broad terms might follow something like that which has just been described or something different. But in all of them, there are going to be real complexities, real uncertainties, a huge amount of emotion, trauma, and that is going to have an implication for what we do as lawyers later in the process, representing our clients. So Before we go on to the science, as far as we can discuss it, and the neuroscience, Sharon's going to start off with some of the law in this area.
Thank you, Damien. That's given us much food for thought. I'm going to deal with just a couple of cases which give us some really helpful guidance in terms of memory and the infallibility of memory. The first is the Lancashire County Council versus the Children, 2014 EWHC 3 FAM. There will be links once the recording of this seminar is up on the 42 Bedford Row website to the case law and to the research papers that we're going to be talking about. So don't worry about taking a note of them now. In this particular case, it's a Peter Jackson case. There are 4 factual matters that I think we just need to have a brief look at. It was a case involving the investigation of whether a child had died as a result of inadequate sleeping arrangements on the sofa where the child had suffocated. So 4 factual points. The child's death by suffocation while sleeping on the sofa was not more probable than not. The medical expert evidence did not demand a finding that the child had suffocated because of the sleeping arrangements, but it did allow for that finding to be made, and therefore it was important for the court to consider the rest of the evidence, the wider canvas. The parents' evidence in this case had been unsatisfactory, but it did not add to the medical evidence, and therefore it was not possible to conclude if the sleeping arrangements contributed to the suffocation, making it unsafe to make any findings against the parents. So with that background in mind, Peter Jackson, or Mr. Justice Jackson as he was then, went on to give some thoughts about memory and how they impacted on the evidence. In particular, it's paragraph 9. I'm not going to read out the whole of the paragraph, but there are just a couple of sentences that I think we ought to draw your attention to. Reported discrepancies. They may arise for a number of reasons. One of those possibilities is, of course, lies designed to hide culpability. Further possibilities include faulty recollection or confusion at times of stress or when the importance of accuracy is not fully appreciated. The possible effects of delay and repeated questioning upon memory should also be considered, as should the effect on one person of hearing accounts given by others. As memory fades, a desire to iron out wrinkles may not be unnatural, a process that might inelegantly be described as story creep. It may occur without any necessary inference of bad faith. Damon, I don't know about you, but how many times do we have cases where so many of these factors come into play? But it's not very often that factors like this are actually brought into submissions. Or certainly not often enough from my experience. Clearly, reading the whole judgment is really important actually to get a really good understanding of why Peter Jackson came to that particular viewpoint in relation to those factors. But I also wanted to just have a quick look at Re-A, a child. It's a 2020 case, EWCA, CIB 1230. This was a case, it was an appeal concerning findings that had been made against a father who had poisoned the mother and the maternal grandparents, resulting in the grandfather dying as a result. The guidance that was provided in that particular case by Justice King is really helpful to practitioners as to the need to be aware of the fallibility of memory and the impact of giving evidence, and also commented on the relevance of these principles in family proceedings in particular. So I'm going to, again, just look at a couple of the paragraphs rather than the whole judgment. It's really from paragraph 40 onwards, but there is a real need to be mindful of the fallibility of memory and the pressures of giving evidence. The relative significance of oral and contemporaneous evidence will vary from case to case, but what is important, as was highlighted in the case of Kogan, is that the court assesses all of the evidence in a manner suited to the case before it and does not inappropriately elevate one kind of evidence over another. In this particular case, paragraph 42, in the present case, the mother was giving evidence about an incident which had lasted only a few seconds 7 years before, in circumstances where her recollection was taking place in the aftermath of unimaginably traumatic events, of course, those factors that Damien talked about earlier. Those features alone would highlight the need for this critical evidence to be assessed in its proper place, alongside contemporaneous documentary evidence, and any evidence upon which undoubted or probable reliance could be placed. And that was all really summed up in paragraph 50, where Justice King talks about fairness requiring a rigorous analysis of all of the evidence relevant to the leaning over issue. In my judgment, the judge inappropriately favoured an aspect of the oral evidence of the mother over a significant amount of contemporaneous and written evidence, without sufficiently explaining why she had done so. And this omission, in the judge's view, inevitably served to undermine the findings made against the father. So, given these strictures, what sits behind the focus on the type of evidence that we're talking about and the ease with which we, as practitioners, often forget the limitations? Damien?
Back to me. As usual, Mr. Justice Mostyn has produced an entertaining and erudite exposition of the thinking and the tradition behind the way we approach oral evidence in the cases of AO and LA 2023. He focuses particularly on why we have place such an importance on cross-examination. He describes cross-examination traditionally as having a lofty, almost numinous reputation as the best forensic tool for establishing truth or falsity. And what he sets out there is that the rules by which we conduct our family proceedings, the family proceedings rules 22 to 1A, provide that any fact that needs to be proved at final hearing needs to be proved by oral evidence. And that effectively, the general rule is that oral evidence given under cross-examination is the gold standard. The point about cross-examination is long established in common law. And in fact, it's so fundamental that it's incorporated in the Sixth Amendment to the US Constitution in criminal cases, that the view is that the best way of establishing the reliability and assessing the reliability of evidence is to test it in the crucible of cross-examination. We'll come back to the US system a little bit later as one example of how this has been done. But Mr. Justice Mostyn says that probably the clearest exposition of the limitations of memory and why cross-examination itself may not be, in all circumstances, the answer or the best way to get the best answers is set out in the case of Guestmin, which you'll have seen again. It's often quoted but little read, we suspect, and Credit Suisse, a 2013 case where Mr. Justice Leggett, as he then was, sets out, and we'll go through it, the considerations for memory and the fallibility of human memory in the context of a commercial case. But what both, I think he, but certainly Mr. Justice Mostyn emphasises that those factors, and we'll go through them, are equally applicable to all fact-finding exercises. And for the reason we then will emphasise, are particularly important in the situation we find ourselves in family cases. So again, we will include the references after this webinar, and they'll be available. But the case is Guestmin SGPS SA and Credit Suisse UK 2013. And the key paragraphs where it talks about the evidence based on recollection are 15 through to 21. In essence, and in summary, what he's saying is that firstly, the legal profession and the legal system has pretty much ignored the best part of a century of psychological research into memory and its nature and its unreliability, particularly that of eyewitness testimony. Two of the errors he identifies that we often fall into is firstly to be overconfident in our own memory, particularly when it comes to vividly held memories. So that if something looms large in our memory, memory and seems to be clear to us, we assume that it's accurate. Research will tell us, and just as Leggett emphasised, that isn't the case. Also, we tend to be impressed by evidence given in a confident manner. So the more confident somebody else is in what they say they recollect, the more we tend to assume that it's accurate. And again, that's an error that we fall into regularly and is something that we need to be alive to in our practice. Underlying both those errors and our general thinking is what might be described as a faulty model of memory. And that's what is emphasised in this case, the idea that somehow memory is fixed in time and then gradually fades at a faster or slower rate, but in a sort of predictable way to some extent. What we don't appreciate and we don't tend to build into our thinking is that memory is fluid and it's malleable, and that the mere fact of retrieval itself can lead to a rewriting and editing of that memory. And again, these are things we'll come on to when we deal with some of the research. What again is clear from the research is that external information can intrude into our memories. And this is particularly so when we are retrieving memories and erroneous, but perhaps contradictory or misleading information is given to us, which can then become, in certain circumstances, incorporated into our own memories unconsciously, such that there's a genuine belief that the altered memory is in fact somehow accurate and reflective of what actually happened. The issue is particularly acute when it comes to past beliefs. So in terms of what someone thought they believed a year ago, 2 years ago or more, is particularly vulnerable to changes for all sorts of reasons. And again, the research shows that. Being given new information since the initial event is particularly liable to influence the memories as we recall them. And that's particularly true where our memory may be weak because of the passage of time in any event. The process of litigation itself is something that Mr. Justice Leggett, as he was, emphasised as a real cause for concern because it exposed witnesses to particular biases. They have their own agenda, which may not be to be deceitful, but it's certainly to perhaps support a particular outcome. They may well feel loyalties to other people involved in the case. So it may be that witnesses who come in feel an obligation or a loyalty to the lawyers who have called them and prepped them, to the people whose case they feel they may be supporting. And added to that is the whole process of preparing witness statements, looking at what others have said, the opinion of others, and responding to that in a statement. Again, all these things can influence the memory as it's recalled at that stage by a witness, which may not reflect what they would have said before being provided with these alternative accounts and information. There are a whole range of potential influences through the process, whereby what ultimately happens to a witness is they end up giving evidence of their memory of preparing a statement or what they've been told as much or if more than their own individual memory. There is, as Mr. Justice Leggett said, a real risk that, and it happens for all of us, of reconstructing memories. As I mentioned before, the process of editing our memories, depending on where we are and who we're talking to, and what advantage, albeit unconscious, it can give us. So that there is a real concern, and this is the conclusion that was arrived at in that case, that in commercial cases where there's alternative documentary sources to be relied upon, there should be limited, if any, reliance on oral testimony for certain types of evidence. And it's only really about attitudes, current attitudes, and interpretation of documents that in certain commercial cases, oral evidence would be helpful. This is therefore particularly important in family cases, and as such, it's been incorporated both in, as Sharon will describe, in rules and regulations that we have available to us, but again, we've probably overlooked.
Thanks, Damien. So the potential dangers of placing too great a regard on oral evidence based on a witness's memory, and in fact not just oral evidence, but evidence contained within statements as well, has been incorporated into paragraph 1.3 of the appendix to the Civil Procedure Rules, Practice Direction 57AC. This practice direction states in particular that witnesses of fact and those assisting them, so that's their legal team, to provide a trial witness statement should understand that when assessing witness evidence, the approach of the court is as follows when it's regarding human memory. Number one, it's not a simple mental record of a witnessed event that is fixed at the time of the experience and fades over time, but is in fact a fluid and malleable state of perception concerning an individual's past experiences, and therefore is vulnerable to being altered by a range of influences, such that the individual may or may not be conscious of the alteration. Now, these principles have also been reiterated for us in family proceedings in paragraph 14 of the President's Memorandum on Witness Statements, which is the 10th of November 2021. And again, the link to that will be on the website. And that really leads us to considering some of the research in not as much detail as we would like to do, because that I think would take most of the evening, but just to really refer you to articles and research that needs to be looked at, and we're going to pick up just on a couple of points from those. What's absolutely clear when you look at any of the work that's been done away from the legal field is that there is really active debate, certainly over the last 5 years, regarding memory issues, in particular with witness testimony and specifically with eyewitness memory. Word of caution, when I say active debate, what I actually mean is it's a fierce active debate. It remains fierce. And as with any area of science, it's a journey that the researchers and the academics are clearly on. So the first paper that we'd like to refer you to is called Rethinking the Reliability of Eyewitness Memory. It's Wickstead, Mix and Fisher. And again, the link for that will be on the website. As I've already alluded to, much of the research really relates to eyewitness memory, but in particular to those cases where DNA evidence has then exonerated a defendant, and so who had originally been convicted because of eyewitness testimony. And so these are the particular cases that they've been looking at. And what they come to the conclusion of is that there are certain pockets within the academic psychological world that have come to appreciate that eyewitness memory is more reliable than it was once believed. And the prevailing view by far is that witness memory is unreliable as a blanket assessment, that's what increasingly pervades the legal system. Eyewitness memory is reliable if it's not contaminated and if proper testing procedures are used. And that conclusion applies really to eyewitness memory on a broad summary, whether the test involves recognition, so if, for example, from a police lineup, or recall, so during a police interview, for example. And eyewitnesses typically provide reliable evidence on an initial uncontaminated memory test, and this is true even for the most wrongful convictions that were later reversed by DNA evidence. That's really broad and in some ways difficult for us as family practitioners to try and distill. But there are some really important points within there, and you can see that it's not even certain within the psychological world as to which parts of the academics are committed to which conclusions. The second paper is Reasons to Doubt the Reliability of Eyewitness Memory. It's a commentary on the paper that we've just looked at by Wade, Nash and Lindsay. They drew on a large body of mock crime research using a small number of field studies, which indicated that high confidence eyewitness reports are usually accurate, at least when memory is uncontaminated and suitable interviewing procedures are used. And I'm going to talk a little bit later about vulnerable witnesses and the impact of the things that we've talked about on evidence from those that are vulnerable. But that's clearly relevant in terms of suitable interviewing procedures and suitable questioning. In this paper, they agreed with the thrust of the previous paper's arguments, but they also argued that there was a comparable risk of overselling an eyewitness's reliability. And they give two reasons for that. Firstly, that psychological science does not yet offer a good understanding of how often and when eyewitness interviews might deviate from best practice in the ways that compromise the accuracy of the witnesses' reports. And secondly, witnesses may frequently be exposed to pre-interview influences that could corrupt reports obtained in best practice interviews. So you can see the real difficulties within that. The third and final paper that we're going to just have a brief look at today now is Convicting with Confidence, Why We Should Not Over-Rely on Witness Confidence. And that's Berowitz, Garrett, Fenn and Loftus. It's a 2022 paper, so really the most up-to-date that we could find. And what they came to the conclusions of was that while there is a really strong consensus that courtroom confidence in eyewitness testimony is problematic, academics now recognise that an eyewitness's initial confidence in their first identification in certain contexts can be of value. And a few psychological scientists have, on a different level, confidently but erroneously claimed that in real world cases, eyewitness initial confidence is the most important indicator of eyewitness accuracy, trumping all other factors that might exist in the case. And of course, that goes against everything that Damien's talked about, and that we as practitioners know when you have a vast amount of contemporaneous or written evidence that the court has to have a look at and assess alongside everything else, going back to the cases that I referred to earlier. Damien?
Bringing this more towards some of the practical considerations we'll have to have is a very useful and recent paper prepared by the Canadian government. So it's in the context of Canadian criminal justice, but it sets out in a very helpful way how, in very broad terms, memory works, and also particularly how trauma affects memory and recall. Now, this is based on a lot of research that was done and incorporated into best practice there and by trauma teams there on the impact of trauma on adult sexual assault victims as they describe them. And this is a paper that was only published in January of this year. So in order to understand some of the things they're saying, we're going to have to delve a little bit into the science, and I hope that's all right. It sets out the broad process of memory before describing how, when we understand things more clearly in this sense, in terms of understanding the neuroscience of what's going on, how we understand the limitations of memory and the pitfalls we can fall into when we're talking to our clients, or when we're understanding how other people have talked to our clients and what they may or may not have said. So it describes, and we'll go through it very briefly, the three processes of memory that, and forgive me for those that know this, are encoding, storage, and recall. So first of all, we receive information, we receive it through our senses in a variety of ways. We'll hear things, we'll see things, we'll understand them to some extent cognitively, and we'll feel things emotionally. And then what happens is that we endeavour, if the circumstances are right, to store these in various parts of our brain. And there are three broad ways in which these, the things that come to us, the information that comes to us, are stored. Firstly, visual, and then acoustic, and then semantic. And they're pretty self-explanatory. What perhaps isn't so obvious is that what we tend to do for adaptive purposes, because of efficiency and because of survival, is we focus on those things that we feel are most relevant to us. Those things get more attention, and our brain appraises these things as more important and will store them. And those that are seen less significant to us and possibly less useful in the future may well not get even stored. So we have a system where we try to encode, we store certain memories. and then we have to obviously retrieve it. The retrieval is a process both of accessing those memories, those stored memories, and selecting them, albeit not necessarily consciously, and at times, again, not necessarily consciously, reconstructing the stored internal representations that we have. And what happens, according to the research, is that over time, we will edit the information. Again, not consciously most of the time, edit the information which is stored. And that which is most useful will be retained. Things that are seen as utterly insignificant may well simply be lost totally. And other aspects of memory will simply be emphasized and perhaps made more vivid. Now, it's worth understanding that because that's the fundamental process for all memory. But after traumatization, things tend to work differently. So when we're traumatized, what seems to happen is that certain central events connected with a traumatic event get remembered ostensibly forever or potentially forever. And again, this is an adaptive outcome. This is our brain, in terms of our own survival, telling us we need to know this because this could save our life later. So if something's really traumatic, it's a threat, we're very frightened. The chances are in some shape or form, at the very least as an emotion, we will remember that because it's important to remember it. We need to understand, therefore, in traumatic circumstances, how the brain is working to understand what is happening when we either can or can't recall certain things, and when more importantly, our clients can't after traumatic events. We'll delve briefly into the neurobiology of memory here. There are two main brain structures that are important. The hippocampus, which is responsible for what we call episodic memory. That's organizing things that we could probably articulate, memories we could articulate in a chronological, time-sequenced way. And these memories, these explicit memories, are broadly what we think of when we think of memories, things we could recall and talk about, and we could order. So that's the hippocampus. Also, as part of our limbic system, so a much more primitive area of the brain in many ways, is the amygdala. And what that deals with is much more intense arousals, feelings of arousal that occur in certain situations, which will be encoded and stored and remembered, importantly, because they potentially have an adaptive survival advantage for us later on. And it's the interaction of these two systems, the explicit memories stored in the hippocampus and the implicit memories stored in the amygdala, and the interaction between the two at times of stress that cause the features we often see but are not often articulated or accounted for in the legal system. The other main process we need to understand is memory consolidation. When information, particularly in a traumatic situation, is available to us, imposed upon us in an extreme situation, newly formed memories of that information will be fragile initially. It will take some time, as long as there isn't contamination or interference, for that information to become more stably stored and, as it's described, consolidated in our memory so that it's sustainable and durable as something that we can get access to. So those three elements, the working of the parts of the brain that deal with both explicit, chronological, accessible data, the emotional, intense emotional, unconscious feelings that we can sometimes have and that we can't articulate in the amygdala, and the need for time, uninterrupted time and uncontaminated and uninterfered time to consolidate those memories, have informed, in the Canadian system at least, very recently, a best practice whereby those that have experienced trauma are not interviewed at any length immediately. And part of the reason is to do with this need for consolidation of memories. If a traumatic questioning process takes place very quickly after a traumatic event, if it's stressful, if it's challenging, that's the process of talking about it and being asked about it and possibly being tested and challenged on it, that can interfere with the consolidation of the memory, thereby inhibiting even the proper encoding and storage of that long-term memory, such that it won't be able to be recalled later. So the best practice now in Canadian trauma teams within the police force is to have a brief initial interview for these reasons, and also then to follow up after 2 complete sleep cycles, whereby it's considered that consolidation will be sufficiently achieved to then allow a fuller, more detailed interview about events. But going back to those 2 systems of explicit memories and implicit memories in the different areas of the brain, how does the threat and how does threat and highly stressful events affect that memory? Well, what they do is they activate the amygdala. That's where our emotions are recorded and stored. This reinforces and intensifies traumatic memories, again, because it's adaptive to do so. It might help us later. But in doing so, in intensely activating the amygdala, this impairs the activity of the hippocampus, where our explicit memories are formed and stored. And in so doing, we are prioritizing that base emotional survival instinct of feelings, perhaps to get out, to defend ourselves, to alert us to danger situations, over a clear, chronological, detailed account, a sequential account of what is happening. So what tends to happen is that the vivid memories, for example, at the beginning of a traumatic assault, whether it's sexual or violent in another way, is such that the stress hormones, cortisol and also adrenaline, tend to support the intense initial memory of what's happening right at the beginning, to understand what is happening so that we can respond. But if that stress continues for too long, what then happens is it interferes with the retention, particularly in the hippocampus, of memories. And so there's a focus on the initial intense event that's starting, but as the event continues and the hormones overload and flood through the system and interfere with the hippocampus, the episodic memory and the explicit memory, then those memories start to be fragmented. So we may have a very vivid, at times unpleasantly clear memory of the start of a traumatic incident, but then it breaks down. So there are certain things that are burned onto our memory as traumatic incidents, but then subsequent things, subsequent details of what's happening, what happens next, it's not even clear there's a clear time sequence, will not be encoded in a way that's subsequently accessible, because it's perhaps not encoded at all because it's being fragmented, having been overrun by the need to survive. What the consequence of this is, and this is where it becomes important when we can think down the line when evidence is being given, is that whilst there might be a vividness to certain aspects, particularly initial aspects of an event, there will be inconsistencies, there will be gaps, there will be a disorganized and incomplete narrative memory of the whole event. And this is particularly important for the way that interviews are carried out with victims of trauma. And that trauma, in this case, the focus was on sexual assault, but one can imagine easily situations that we encounter in many of our cases where it becomes particularly difficult for a client to go beyond the initial sense of something terrible having happened, whether it's to them or whether it's to a child or to a partner. And so when we do that, we have to remember that it's simply going to be unrealistic and unfair to expect them to record with chronological precision what happened. So there's the issue mentioned earlier of the timing of initial interviews, that it doesn't contaminate and interfere with the consolidation of memory. And then there's the expectations of the nature of the memories that will be encoded, the nature of memories that can be legitimately be expected from people who've been through those kind of situations. And we had a recent example for those following American politics last year in the Senate hearings to approve candidates for the Supreme Court. You may remember the issue around Brett Kavanaugh, who was being proposed, and the fact that allegations were made, historical allegations of sexual abuse by him when a student. And they were made by Dr. Blasey Ford, whose evidence was called and heard at Senate hearings. And as is entirely predictable, knowing how memory works, particularly for traumatic events, she could remember some very vivid details of the central events of what happened, but couldn't recall, perhaps understandably, partly because of the passage of time, but partly because of the nature of events she was trying to recall and the trauma of that incident. She couldn't recall certain details, including, for example, how she travelled home after the party at which the alleged assault took place. And she was vilified and criticised in the press and ultimately not believed and not relied upon in the approval of Brett Kavanaugh in a way which was perhaps a salutary reminder of how lawyers can pull apart if we're not careful about how we think about them. We will pull apart a witness's evidence on the basis of an expectation of clarity that is simply unrealistic and unfair. So these are the problems that we encounter in traumatic events, but they don't have to be as difficult and as traumatic as a sexual assault for these processes to be engaged, as we've said, with our clients. And before leaving this, because it is a technical area, and we will give the references, but it's worth reading because it gives a very clear accounts of how it works and what the limitations of memory are. It's worth reading some other research, which I'll mention, particularly to do with recall and the retrieval of memory. Briefly, most of us think of retrieval as the end process in memory. So we encode, we store, we retrieve, as described before. Retrieval can be the end of the process, but is also, as was mentioned in the Guestman case, it can be the start of another process. And depending when retrieval occurs, depending on what circumstances, depending the context, the goals of the person retrieving, the expectations and the stakes for them, retrieval is also the start of another process. It will inform subsequent behaviour, it will guide what we do later, and affect also how information is stored from that point on. So the same memory retrieved more than once will change. It will be edited, it will be reconstructed, predominantly unconsciously, and it will be done in different ways by different people in different circumstances. Some of the reasons for doing this, as I've mentioned, are the goals of the individual retrieving it. Some of them are to do with the age. We're different in any event, but as people get older, they tend to retrieve in different ways and to access or prioritize accessing certain types of information, probably more positive than negative if possible. And so the act of retrieval itself can influence the storage of memory sitting there, so that there are various ways this can happen. One is that if we retrieve something repeatedly, it may make it more vivid, more clear, and therefore we can retrieve it more easily subsequently. Similarly, if we don't retrieve something for a long time, it may not be able to be retrieved much later. But thirdly, and probably the most problematic, is the risk of retrieval being a process whereby memories are reconstructed and sometimes misconstructed, and they're malleable because of information that we're also being given at the same time. So the process that we have of asking clients to comment when they're thinking about their memories on the memories of others, respond to the statement of such and such because they say this happened, is almost certainly going to have an influence on how subsequent retrievals by our clients will work, and whether they work at all and what their content will be. So retrieval is a tricky process. Sometimes retrieved emotional content can trigger processes that improve the richness and the vividness of those memories. The problem with that is that those memories may be more vivid, having been recalled, but that vividness does not necessarily assist in the fidelity of that memory. Erroneous details can be incorporated and associated with the memory, and certain emotional details can take on a false prominence in our memory. So it's important that those processes affect, when we are retrieving emotional memories, not only the quality of the initial retrieval, but also the quality and the likelihood of any subsequent retrievals. So we have difficulties we've identified in the research, just without going into any real detail, in encoding, in storage, and in retrieval, and all of which, it's not difficult to see, can affect very clearly clients and witnesses that aren't clients, but particularly our clients for whom the emotional context is particularly intense, and can affect them in the preparation for and the participation in the proceedings where we're representing them. And unless we understand that and we think about this, and whether it's addressing experts, whether it's addressing the court on their behalf, or whether it's just thinking about how we deal with our clients and understand them, these things are going to continue, as we, I think, feel they have, continue to bedevil our understanding of what can and can't be expected of clients in family proceedings. And one of those ways, obviously, and I know it's getting on, but one of those ways I think is going to be dealt with, and it's how we deal with vulnerable witnesses.
Thank you, Damien. I see the time, going to go through this as quickly as I can, but it's important because actually what it does is really bring together all of the things that we've talked about with particular reference to what it is that we do on a daily basis. Those of you who have done the FLBA vulnerable witness training will know what I'm about to talk about, but those of you that haven't, it's an absolute must. It really is, and makes much more sense knowing some of the stuff that Damien's talked about tonight. So the major emphasis for us now is really about how vulnerable witnesses, whether they are clients or witnesses who have come in, are treated in court, and in particular how they are asked questions, whether that's in chief, if it's not a child who's given an ABE, or in cross-examination. Someone can be vulnerable for very many reasons, physical, mental or social. And what I wanted to do was just read out an address that Sir James Mumby, who was then president of the Family Division, gave to the Wales Observatory on Children and Young People as long ago as 2015. It's a really nice definition in some ways of the broad spectrum of vulnerability. And it's this: vulnerability comes in many forms, physical, mental and social, to mention but three. Let me give you some examples to illustrate the range of the issues which the family court deals with all the time. For many litigants in family cases, English is not their mother tongue. Some are illiterate, some are deaf or blind, or have other physical disabilities. Studies show, as experience suggests, that a significant number of parents involved in care proceedings often have significant learning disabilities. Another kind of vulnerability is exemplified by the victims of actual or anticipated domestic violence, forced marriage, female genital mutilation, or even worse. So you can see the really broad range of vulnerabilities that present themselves to us on a daily basis. And although Damien's talked in some detail about trauma, of course, ability to recall is also going to be affected by other vulnerabilities, some of those that we've referred to here. Practitioners, such as us, we're often faced with witnesses, clients who are being asked to recall events that were likely to have been traumatic or from a really long time ago. And then when you, on top of that, factor in their individual and specific vulnerabilities, it's quite clear that there's a really complex layer on top of the matters that you're trying to deal with. So where do we go to as practitioners, and what is it that we need to be looking at? The starting point is the Family Procedure Rules 2010. The general rule for family cases is that evidence which needs to be proved is done so by a witness during the course of their oral evidence. Damien's already talked about oral evidence being the gold standard of cross-examination. Rule 20.1a, with their statement standing as their examination in chief. Part 22, now also needs to be looked at in the context of rules which came into force at the end of 2017 regarding vulnerable witnesses, and those are Part 3A and Practice Direction 3AA. The relevant part of those for the purposes of our discussion tonight is Rule 3A.5, which places a duty on the court to consider how a party or a witness can give evidence. And there are 2 points that need to be looked at. The court needs to consider whether the quality of the evidence, whether it's a party or a witness, is likely to be diminished by reason of vulnerability. And if so, needs to go on to consider whether any participation directions are required. And before making any participation directions, the court must consider any views expressed by the party or the witness about them giving evidence. So we really need to hear what they're saying. And what we as practitioners need to take from that is that the quality of the evidence it needs to be as complete as it can be, but it also needs to be coherent. It needs to be as accurate as possible. And that really relates not just how we ask questions, but that we ask those questions in a way to elicit the best quality evidence that we can. And that's also relevant not just cross-examination or examination in chief, but as far back as producing statements. And of course, when we are considering the analysis of ABE interviews, it's important, of course, to remember that this applies not just to vulnerable adults, but to children as equally. And really, what I come back to is the point that I made at the beginning of this particular area, is that training in dealing with vulnerable witnesses is really imperative for any of us advocates. Being able to understand how it is that their evidence is going to be affected and what it is that we need to do to ensure that we have the best quality evidence from them for our clients and for the cases that we are putting. The scope of this discussion is not to go into all of the details in relation to that. And I do see that we've been talking for about an hour, Damien. I'm going to put some more details onto the website with the links that we've referred to, just to guide you as to where else to look for further research in relation to this particular area. But it's really relevant to the issues of memory and the issues of ensuring that we have the best quality evidence in order to be able to put our clients' cases as properly as possible.
I think we're bang on 17:59, so we have to wrap up. You'll be relieved to hear we've barely scratched the surface of memory, but I hope it's been at least to some extent either interesting or useful, or both, but possibly neither. Anyway, thank you for listening. I think there's one further thing. I think Sharon's got a book coming up.
I have. Thank you, Damien.
Well, for those who are interested in...
it's a practical guide to practitioners' illness in care proceedings.
Right.
Available from Law Brief Publishing.
Yes, and all good book types. All right. Anyway, thank you very much.
Thank you.